Hello, it's Philip Taylor speaking from Richmond Green Chambers, and I'm looking this morning at a book from Law Society Publishing. It's a book which brings together the various orders you can get, called Preventative Orders. It's a practical guide in the legal handbook series, and it's written by three people, Edwin, Buckett, Tom Little and Robert McAllister. There's some blurb on the back. There's our Flickr review there, which my wife Elizabeth and I have written. This is the book itself, and you can see it has standard cases at the front. It then follows the normal thing of having paragraph numbering at the sides there, which is helpful. And then we get quite quickly after chapter 13, which deals specifically with appeals. We then move straight on. There's the appeals section. We then move straight in halfway through the books to the three main appendices. Now let me tell you a little bit about what we think of the book. There is, by the way, a useful, very short index just at the back. We've given it the title, A Collective Review of Preventative Orders. Now what do we mean by that? Well, we mean the following. We say that the three authors from Gough Square, Buckett, Little and McAllister, have produced an important and much needed collective review of the wide range of preventative orders currently available in the courts. Lord Justice Hooper, in his foreword, comments that this commends this comprehensive book as compulsory for any of those who have applications for preventative orders across a range of professionals involved in the criminal justice system, not just policemen but obviously local government officials and so on. Law Society Publishing therefore produced another excellent legal handbook in their series of these highly practical works, and this guide explains the wide range of preventative orders collectively in a single volume in actually under 400 pages. There are 13 chapters and 3 appendices, including sample prohibitions, relevant extracts from statutes and from statutory instruments. The 7 main orders are analysed with detailed reference to both legislation and procedures, which I think will be helpful for all. The strongest aspect of this guide is the exploration of the types of order and the identification of the common difficulties and problems which overlap specific orders, including the required standard of proof and the rules on hearsay evidence. It's long been recognised that these orders create important difficulties for both lawyer and judge. As Hooper says, it's because of the inherent tension in balancing the protection of the public with the protection of the rights of those who are the intended subject of such orders that causes the difficulty. We think the book succeeds because of its guidance to those considering the tension element and producing a reasonable outcome which will not receive attention in the "you could not make it up" column of some national newspapers. At a time when it's clear that the methods of dispensing justice will be reconsidered anew by the coalition government, Preventative Orders remains a practical and authoritative statement for those seeking both freestanding and post-conviction preventative orders, always remembering a breach of these orders constitutes offences carrying significant periods of custody. The authors write that the last 12 years have seen an explosion in the use and enforcement of preventative orders, although their long-term usage may well be in doubt, as the view of some is that they don't work. It's interesting to note that in the past almost all injunctions against individuals were brought under private law proceedings, mainly in the county court for domestic violence. With the ASBO and other freestanding application orders, the conviction of a criminal offence has been partially bypassed, hence the issue of tension which Hooper referred to. Let me conclude by saying there's a useful section on human rights legislation and some detailed recent case law which makes this work a highly practical work for the current criminal practitioner, including appeals in the final chapter. The authors have included a short page on the future, that's actually right at the beginning, giving an assessment of the new government's point of view, writing by saying it's very likely that there will be a change in the near future, at least in emphasis. So I suggest you refer to the Home Office website for updates to see how these changes take effect. However, the effect remains to be seen. But thank you to the three authors and Law Society Publishing for an extremely useful book for our bookshelves. Bye bye.